Good afternoon. I am Elizabeth Savage, and I am a fellow with the Legal Aid Disaster Relief Project. I hope that everyone is staying healthy and safe during this time. Today, we're going to provide an overview of estate planning and why you should be considering estate planning during your recovery process or in preparation of a disastrous event to aid in a quicker recovery process in the future. This presentation is not intended to be legal advice. If you are watching this presentation and have a specific legal question or problem that you would like assistance with, please call the Legal Aid helpline at 1-866-219-5262, or you can submit an application online at legalaidnc.org. And at the end of this presentation, I'm going to go ahead and give that information to you again. First, I want to provide a brief overview of Legal Aid of North Carolina and the Disaster Relief Project. Legal Aid is a statewide nonprofit legal services organization that provides free legal services to eligible individuals. Legal Aid's practice areas include Social Security and other benefit programs, domestic violence advocacy, unemployment, housing, education, consumer, expunctions, and disaster relief. The Disaster Relief Project of Legal Aid provides free legal services to help disaster survivors with their recovery process. Recently, we are focused on long-term recovery from Hurricane Florence for individuals and communities. Our project assists with consumer protection matters, including insurance issues and contractor scams and fraud, landlord-tenant and property ownership issues. We can assist with legal issues that prevent access to recovery programs or assist with connecting you to long-term recovery resources. We can also draft simple wills and deeds and other estate planning documents, which we're going to go into more today. So why do we need to do estate planning, and why should you consider it during disaster recovery? First of all, what is estate planning? It's making sure that your plans for the future are known and legally protected. This is generally accomplished through legal documents like last will and testament, power of attorney, healthcare power of attorney, and other will substitute methods. Essentially, estate planning protects your assets, your property, your health, and your overall wishes for what you want to do in the future. Last will and testaments. A will is a legal document that governs who receives your assets and property after you pass away, and who manages your assets until they're passed on to your heirs. So what happens if you pass away without a will? Well, North Carolina laws will govern the distribution of your property. This type of distribution under North Carolina intestacy laws, this schematic may not align with your particular intentions and who you want to receive your assets and property after you pass away. In order to direct exactly what you want to happen upon your passing, you should execute a will. And a will must be executed properly to be valid, and unfortunately, there are situations where someone may believe themselves to be the rightful owner of property because it was devised to them, but maybe the will was not actually executed properly, and so legally they aren't actually the owner. For example, you may consider yourself to be the sole owner of your family's land because your last living parent who owned the property told you before their passing that the land was to be yours. And for decades, you have been the sole resident on the property, you've been the only one paying taxes, and you're the only one making repairs, so on and so forth. Well, in this situation, unless there is a properly executed will lying around somewhere that we don't know about, your parents' action did not actually give you legal ownership of the land. The land passed through the North Carolina intestacy statutes and is actually owned collectively by all of your parents' heirs. So in some family situations, especially where property has passed down in this manner for multiple generations, the property can be owned by an upwards of 100 people or more. And I know that's a little exaggerated, but and it may seem extreme, but it is possible. And so you should really consider the future distribution of your property when you are in your recovery process. So how does this relate to hurricane recovery? Well, a couple of different ways, but a common reason comes back to proving the ownership of the property. A will that shows that property was devised to you can actually remove barriers that you may be experiencing in the recovery process and assist you with showing full ownership rights. There are other legal alternatives out there that, other than creating a will, that can assist you with the distribution of your property and assets. And these are called will substitutes. I'm not going to get into all of those substitutes today, but just know that there are other methods out there, they exist. And if you're interested in learning more about this, would like to draft a will or just discuss your alternatives, please give us a call. Power of attorney and healthcare power of attorney. A power of attorney, or you may hear it abbreviated as a POA, is a legal document that allows you to grant authority in another. This other person is called an agent to take certain actions on your behalf, and a well-drafted POA will make very clear what you are directing the agent to do for you. The great thing about POAs is that they are extremely customizable, and you can set limitations on the power that you give your agent. A power of attorney can be durable, meaning that it can last after you become incapacitated, or you can choose for it to either stop or start at the moment that you become incapacitated. Many people use POAs to assist with their financial matters, but there are also healthcare powers of attorney, and we will discuss those very briefly later on as well. Generally, a power of attorney can be very helpful in the disaster recovery setting to allow others to make recovery decisions on your behalf. So for example, you can grant a general authority to someone like a family member with respect to real property that you own, so that they will have the authority to make recovery and repair decisions regarding that certain piece of property. It could be like your home. And so it may take effect upon incapacity, or you may want it to be in effect regardless of whether you can make decisions or not for yourself. But either way, executing that power of attorney for that specific purpose would allow whoever you choose to be your agent to make those recovery-related decisions about the property. And this is really important during the recovery process because you never know what's going to happen in the future, and especially where you may not be able to make decisions for yourself about your property. If you haven't executed this type of document, then unfortunately your family members may not be able to do anything to be able to repair your home in the event that it's damaged or destroyed because of a disaster. A healthcare power of attorney grants an agent to make your medical and healthcare decisions if you can no longer make them for yourself. Having this type of POA does not allow for the agent to make just any decision for you. So if you have a healthcare power of attorney that does not, just by having an HPOA, that does not also allow the agent the same power to make other decisions or take other actions unrelated to your healthcare and medical needs. It is very limited to healthcare decision making when you can no longer make those decisions for yourself. And so if you have a healthcare power of attorney and are trying to rely on that as the way to let your other family members or whoever you chose as your agent to make other types of decisions like about your finances or your property, that will not be a valid way for them to do that. And you will probably need to reach out to us if you can and talk through what you would like that agent to be able to do other than make healthcare decisions, because at that point you'll also need to look into having a power of attorney, non-healthcare related power of attorney drafted for you. I want to thank everyone for their time today. I hope that this session was helpful in understanding the importance of estate planning in a disaster recovery context. We went very broadly over estate planning documents, the most common types at least. And if you would like more information, please reach out to us on how those documents can help you in your recovery process. Recovering from a disaster can be a very long journey. And although estate planning may not likely be a high priority on your recovery checklist, poverty can prevent the prioritization of these long-term planning documents because the focus tends to be a day-to-day, week-to-week, month-to-month, and not years and generations. But nevertheless, for the reasons we briefly discussed today, estate planning is very important and can help you and your family overcome barriers that you may be facing or may face in the future during your recovery process. If you are interested in our services, please reach out to Legal Aid. You can call us at our helpline. The number is 1-866-219-5262. Or you could visit our website and submit an application online. If you would like to have another video on this topic or would like to hear more about a different disaster recovery topic, please let us know in the comments and we will help get that information out to you through this Facebook Live method. Thank you so much, everyone. I hope you all stay safe and healthy.